Hello, good afternoon. Today is Thursday, April 20th, 2023. My name is Ashley Glover, and I'm here with attorney Kim Christian, and we are happy to welcome you to our webinar, Why Do I Need a Healthcare Proxy and Living Will? So let's get warmed up with a few housekeeping items. We should be together for about 30 minutes. We put together a PowerPoint, which is being shared on screen along with our webcams. To help minimize background noises, your mics are muted, so you'll want to use the Q&A box to submit questions. We've saved time at the end to answer as many as we can. Feel free to chat with us or each other in the chat box. Also, we are recording this and we'll email you a link to the recording. Finally, we value your feedback, so please let us know how we did in the webinar survey. That will appear on your screen once the webinar ends. All right, so now I'd like to introduce our presenter, Kim Christian. Kim is a dedicated partner at Russo Law Group. She's been with the firm for over 15 years, helping clients with elder law, special needs, as well as estate and trust planning. She's the lead planning attorney in our Lido Beach office. She also meets with clients in our Garden City location, virtually, and home visits. So Kim, thank you so much for being here. Wouldn't be able to do this without you today. So I'm going to hand the floor on over to you.
Thank you so much, Ashley. Happy to be here. And welcome, everyone. Thank you for joining me today. It's a very nice day outside, so that's good news. And let's just get down to it, what we will cover. So today, what we will cover is what is a healthcare proxy and a living will, just so we get an understanding of what each of these documents mean and what each of these documents do. Why do I need a healthcare proxy and living will? We'll have a very firm discussion about why it's so important to have these two documents. What happens if I don't have a healthcare proxy and a living will? So the consequences of that are also very important. And then, of course, what's the next step? What kind of action step do I want to take to make sure I am covering myself in the event a healthcare proxy or a living will is ever needed to be used on my behalf? So I start with the must-have legal documents. Now I can see that there's documents on here that aren't the healthcare proxy and aren't the living will. But the reason I started with this slide is because the healthcare proxy and the living will is part of the must-have legal documents. Sometimes I have people come to me and they say, what is it? Absolutely, Kim, if there's something that I need to have in place, I call it a foundation. If I need to have a foundation in place, what are the documents that consist of this foundation? So, of course, based on this presentation, we want to make sure you have your healthcare proxy, your living will, and your medical authorization. That's a HIPAA release. You're also going to want a durable power of attorney and also a last will and testament and/or a living trust. The durable power of attorney is for financial decision making. It takes no power away from you, but if you need or want someone to make financial decisions for you, this is the document that's legally going to nominate those individuals. Then we get, of course, to the healthcare directives. That is our focus today. The healthcare proxy is a document that nominates an individual to make healthcare decisions for you. The living will is a document that puts forward your instructions as to end-of-life decision-making. Then a medical authorization, we'll talk about that more in detail as well, but it is an authorization that says my agent under the healthcare proxy can access my medical records, speak to my doctors, so that no one is making a decision in a vacuum. They're in fact making the most informed decision for you as possible. Then, of course, part of your foundation is your last will and testament and/or your living trust, right? You want to make sure that at the end of your life, your roadmap is put in place and people can follow exactly what you want to have happen with your estate when you pass away. All right, so let's focus on those healthcare directives. We're going to start specifically with the healthcare proxy, right? The healthcare proxy has to do with who has the right to make healthcare decisions for you. And my first prong is very straightforward. It says you have the right to make your own healthcare decisions. So if you complete a healthcare proxy, but you are capable of making your own healthcare decision, the healthcare professional will always consult you first, right? So you always have the right to make your own healthcare decisions. The proxy is here in case you are unable to make your own decision and you need someone to step in and make those healthcare decisions for you. So the proxy is the document that designates the agent who's going to make healthcare decisions for you. The agent is the person or persons that you pick. And I said persons because if you can, not everybody has candidates for this, but if you can, you want to put a primary agent and then successors after. So for example, my spouse, then my daughter, then my son. That would be an example of a succession of order of people who could make decisions for you. It's effective if you can't make your own decisions. So that prong there that says effective if you lack capacity, what that is saying is, well, now if you lack the capacity to make your own decisions, you're unable to, then this is the voice for you. These are the individuals that's going to make that decision for you. You can specify organ donation, and I think that's really important because right now, this is organ donation month, a gift of life. So I really wanted to put that in there. If that is something that you are interested in at the end of your life, you can certainly designate that in your healthcare proxy. And every individual is different. So if there is a reason that you don't want to, you don't have to. You can check off that I don't want to. You can even limit it. You can say, I'm okay with just donating this part or that part. Some people choose to write, I will donate any needed organ or part. Some people even say, I'd like to donate it for study, which is also a valid choice. So in the healthcare proxy, and in light of this month, there is a part where you can designate how you feel about organ donation. You can also speak to artificial nutrition and hydration. That's very important. Toward the end of your life, if there is no chance of recovery, and we'll talk about the living will in a moment, what is your position on artificial nutrition and hydration? And you should be very specific about that so your agent under the proxy knows what you would want. So let me go back to the healthcare proxy again. The healthcare proxy is a document that says, if I cannot make my own healthcare decisions, these are the people who I want to make the healthcare decisions for me. This is a document where the person that you nominated can make decisions from the smallest decision, should I have this medication, to other decisions, should she have this surgery, to consulting with healthcare professionals to understand the depth and breadth of what is going on with the person's healthcare situation, all the way to end of life decision. So one of the keys to the proxy is making sure you pick a person who, in fact, is going to carry out what your wishes are. Now let's talk about the living will. The living will is an instruction as to the withdrawal or withholding of extraordinary life-sustaining treatment. So we talk about who has the right to make life-sustaining treatment decisions for you. Well, you can make your own decisions. And one of the ways to do that is to put it in writing so your proxy, if it ever gets to this point, has a full understanding of what you would want should you need extraordinary care, right? And would you want to be kept alive that way? So as I said earlier, the living will is an instruction that says, this is what I would want in the event I needed extraordinary life-sustaining treatment. All right. And some people choose to put triggering events, right? They may give a certain time period. They may say this is what needs to happen. For example, many of our clients have in their living wills, the triggering event is that two doctors believe that you are in a permanent vegetative state, or you have a terminal illness with no chance of recovery, right? So it is a very high threshold. Two doctors must agree, particularly in the documents that we prepare, that you are in fact in that situation. This reflects your belief. So when we talk about this in our planning meetings, I always say, this is really a personal document. So you want to make sure that you read it over and you discuss it, and you discuss it with your healthcare proxies that you nominated too, right? Because now you're confronting a decision that you would want to have made for you regarding your end of life decisions. Also, you have the ability to specify whether you want pain relief medication. And I appreciate this. So for example, your living will may say, in the event I am in a permanent persistent vegetative state, I have a terminal illness, there's no chance of recovery, but for these life-sustaining treatments, but for these extraordinary means, I would pass, let me go peacefully. But then it says, even all the things that I stipulate that I don't want, what I am okay with is pain relief medication. And I think that's an important part of your end of life plan. If that's something that you feel that you want, you can put that in there and say, yeah, I don't want any extraordinary means, but I also want to be comfortable, and I would authorize pain relief medication. So the question is, would you want extraordinary life support if you have no chance of recovery? Because in New York, the law presumes that you do want life-sustaining treatment unless there is clear and convincing evidence as to your desires. In New York, the living will is a valid legal document that meets this evidence requirement. Okay, a living will provides instructions to your proxy, to your agent under your proxy, or to the healthcare provider, the doctor, for example, as to what you would or would not want regarding extraordinary life-sustaining treatments under certain conditions. So when I have a planning conversation with anybody who is doing their estate plan, and we're building that foundation that we spoke about earlier, when we start to talk about the living will, we have a conversation, just a conversation to understand, would you in fact want extraordinary life support if you had no chance of recovery? And then we start to sort of tease it out and talk about the different details and the different scenarios, because everybody has different feelings on this, and it's very important you identify what it is that you feel. So the living will allows you to say, I would not want life-sustaining treatment under certain conditions, and it allows you to set forth those conditions and to say, let me go without extraordinary means. But again, we talked about being okay with pain medication if that's something that you wanted. So now let's talk about, we talked about what, right? We talked about what the healthcare proxy is and what the living will is. So the healthcare proxy is the document that designates who is going to carry out your healthcare decisions. Now it's everything from the smallest healthcare decision all the way to the biggest end of life healthcare decision. That's the who, right? And the living will is the instruction. Healthcare proxy, medical professional, this is my instructions as to what I would want in the event I was in a situation that required extraordinary means. So who makes the decisions if you don't have healthcare directives? So this is going to fall under the consequences, right? So what if I didn't get a chance to do them? What if I don't do them? What if I don't have them? What could happen? Well, frankly, your healthcare decisions can be limited or compromised, right? You may end up having someone that you would prefer not making your health decisions, making them for you. You certainly can lose your assets, even lose your personal dignity if they're not going to follow what you in fact would have wanted, right? No one has a legal right regarding personal assets and things of that nature. And guardianship proceeding, right? We've seen situations now where families are fighting and they think they should have the decision over who should make end of life decisions for someone, and not just end of life decisions, any healthcare decisions. Now you end up in court, and now someone is petitioning to become your legal guardian. When if we just had our foundation in place, then we would have avoided all of this. So there is something called the Family Health Care Decisions Act, because what was happening is that people were not getting around to doing their healthcare proxy, and it was an issue because now we were resulting in a guardianship situation. So in March 16th of 2010, the Family Health Care Decision Act was put into place. And the FHCDA allowed a healthcare surrogate to make healthcare decisions for a person, including end-of-life decision, if the patient lacked the ability to make decisions, if there are no advance directives, and the person is in a hospital or in hospice. All right, well, we know that there are other scenarios where we have to make decisions where we're not in a hospital or in a hospice. So what then? That is very problematic. And the second thing that's problematic, and I'm grateful for this statute, but you cannot rely on it. Because number one, you don't know where you're going to be when you need that healthcare decision. And number two, if the statute appoints a person that perhaps you wouldn't want making the healthcare decision for you, then you most certainly want to be proactive and appoint the people who you would want. So there's a hierarchy. So let's say I didn't have a healthcare proxy and I was in a hospital. The hierarchy is as follows. If you already have a guardianship, so you already have a guardian for another reason, then your guardian is the first one to make that decision. If not, it's your spouse or it's your domestic partner. If not, it's then your son or daughter. Then it's your parent. Then it's your brother or sister. And then it could be a close friend. So on its face, if every family was the same, then this may or may not be an issue. With that said, we all know that every family is not the same. And perhaps the son or the children don't get along. Now we have a statute that says it's your next of kin. But we haven't said that your daughter can do it or your son could do it or delineated in order. So now there again is going to be conflict, likely resulting in a guardianship, likely resulting in your treatment and your decisions that may or may not be followed because of this conflict. What if you wanted your daughter to do it? She was a doctor, and despite the fact that, you had a spouse, it made more sense. Well, this hierarchy would not allow for that. So you want to be cognizant, you want to be as proactive as possible so that you are naming, in fact, who you want to be making those healthcare decisions for you. All right, guardianship. Now, what if I do get to a point where somebody has to petition the court to become my guardian? Well, there's two prongs to a guardianship. There's guardianship of the person, so my personal aspects of it, and then there's guardianship of my property, and that would be financial and things of that nature. So a guardian can also make an important personal decisions for an incapacitated person. They can make routine and major medical and dental treatment. They can handle your living arrangements. They can handle education and training opportunities. They can even apply for means-tested programs, government benefits such as SSI or Medicaid if you need that kind of healthcare coverage. All right, so before we move on to how you protect yourself, let's just go back to what if I don't have a healthcare proxy and a living will? So number one, if I do have a healthcare proxy, I can be certain that the person who is making healthcare decisions for me is the person that I chose. It is absolutely the person that I know who knows what I would want, and who is in fact in a position to carry that out, right? I can be as close as can be with a person in my family or a person in my life, but I can know they will never be able to follow what I want. And for many reasons, it's not a bad thing. It may be an emotional reason, whatever the case is. You have to make sure you're appointing the person who is going to, in fact, follow your wishes. If you don't have a proxy, right, there is the Healthcare Decisions Act, but again, we want to be as clear as possible who we want making our own healthcare decisions. And if I didn't have a living will, well, then if I ever got to a situation where I'm confronted with not having extraordinary means, it could be extremely problematic without that living will. I always say the living will serves for multiple reasons. 2 legal reasons, 1 personal reason. The 2 legal reasons are the following. If I am carrying out withholding extraordinary means, then my medical professionals and frankly, my healthcare proxy wants to be released from any liability as long as they're acting in good faith, right? Those are 2 legal reasons. I also think the emotional reason is very important as well. For example, if I name my daughter to be my proxy and I have a living will that says I would not want to be kept alive by extraordinary means, in the event she is facing that decision, she can say, this was my mother's wishes, this was my mother's decision, not mine, and I'm going to follow those. So we keep those in mind when people are wondering whether they should, in fact, have these documents in place. All right. How can you protect yourself? So you definitely need a plan that protects you. I have so many planning meetings where they say, well, I want to make sure I protect my family. I want to make sure that I do the right thing by my family. And I say the best way to protect your family or your beneficiaries or the important people in your life is to protect yourself. Make sure that you have that foundation in place that I talked about earlier. So in the event there is an unexpected situation, we are ready and we are prepared. So you can make sure you access the care you need. You can control how healthcare decisions are made with healthcare directives, right? That's your healthcare proxy. That's your living will. These documents can be changed at any time. So as relationships grow and change, things develop, right? You can always change these documents. And of course, we're always available to assist you with the drafting and supervision of these documents. And not only are we available to assist you with that, but we're available to talk about it with you, because I think talking through your plan and understanding what you want, in fact, in a situation like this is also very important. All right, so what do I do now? I'm sure just based on what I just went through, you know, I am going to advocate wholeheartedly that you create a plan. You make sure that you have these in place. You make sure that your legal documents are comprehensive and up to date. I call it the checkup. You may say, hey, listen, I have a healthcare proxy, I'm living well, I'm good. And I say, well, then have it reviewed. Make sure it does what you want it to do and it says what you want it to say, right? Because sometimes things change. So it's important that you make sure you have these legal documents. And if you already do, just make sure they're up to date and it says what you want them to say. And of course, you wanted to make sure you get that plan implemented. So before I move to questions, and I will move to questions in 1 minute, I just want to do just a summary. So the healthcare proxy and the living will is very important. The healthcare proxy is the document that nominates the individual and then the successors that will carry out your healthcare wishes. From the smallest wish, should I have this surgery? Should she take this medication? All the way to end of life decisions. The healthcare proxy also allows you to designate whether you'd want to donate your organs, any needed organ or part, a specific needed organ or part, to science and research, or no organ donation at all. But in fact, the nice part is you have the opportunity to express your wishes, whichever they may be. The living will is your instruction about end-of-life decisions. In the event I am in a permanent persistent vegetative state, I have a terminal illness with no chance of recovery. This document says, if 2 doctors agree I am at that threshold, let me go peacefully. You can modify it in different ways to have different stipulations, but that is in effect your instructions about end-of-life decision. What happens if you don't have them? You are leaving to chance then who is going to be making those decisions for you, and are in fact your wishes going to be carried out? Again, from the smallest to the biggest. So we know our next step is to review any existing legal documents that we have, or in fact, to get our new ones in place. This is extremely important. I can share with you, I had a personal experience where I was temporarily unable to make my own healthcare decision. And I was very grateful that the proxy that I had picked, did exactly what I would have done. I didn't doubt any differently, but more importantly, I was comforted going in, knowing that I did have these documents in place in case something like that should happen. So I appreciate you all listening to me. I'm going to now go to the question and answer portion. Let me pull them up. I think, here we go. So first one, does the designated agent or successors named in the healthcare proxy have to sign, notarize the document agreeing to their being named? I thought that was the case of the power of attorney, but is this the case for the healthcare proxy? Excellent question. In New York, the proxy does not have to countersign accepting to be the proxy. You are correct. In New York, the power of attorney, the agent does sign, the primary agent signs, agreeing to be the agent under the power of attorney, but for the healthcare proxy, they do not. With that being said, I do think it's good practice that you share with them your wishes regarding medical decisions if you have named them as healthcare proxy. Melanie says, hi, this is great. This info is great. I appreciate that. She has a couple of questions. When I get my documents completed, do I need to file it with my doctor or hospital? Should I give my appointed people a copy? Also, can I appoint 2 people to share in making decisions on my behalf? So when you get your documents completed, there is no mandate that you have to file them with your doctor or hospital. With that said, if you wanted to provide, for example, your primary care doctor or your cardiologist, somebody that you see and that you're committed to, a copy of it, that is perfectly acceptable, if not recommended. The hospital's a little trickier. You don't know when and where you will be. So you let your proxy know if they ever need to produce that for you. Should I give my appointed people a copy? That's a personal decision. Some people share with them who to call if there's a situation like that and they don't provide them a copy. Some people absolutely do. And if they decide to change it, they'll let them know at that point. So it's a personal decision on that one. Also, can I appoint 2 people to share in making decisions on my behalf? The healthcare proxy, you would not. The healthcare proxy is a succession. So you would have a primary, then a backup, perhaps another backup to that person, but they would not be on the same level. And if you think about it, it makes sense, because if there is a critical decision to be made very quickly and there's a disagreement, it could be problematic for you as the person who needs the care. The power of attorney, however, you can have 2 people as the primary agents. Do I need these documents legalized with the court? No, these are not court documents. These are documents you do separate and apart outside of the court's jurisdiction. I think, Ashley, there was another question that came through during the registration, and I want to make sure I cover that.
Yeah, I'll go ahead and read that out.
Thanks.
Yeah, who has priority, the beneficiary in your will or the beneficiary in your assets or accounts? Can the person named in the power of attorney manage your estate while the person is living, or only after the person expires?
Okay, so let's start with the power of attorney question. I'm going to start backwards today. So the power of attorney is for financial decision making. The power of attorney is only valid while the principal is alive. So I am able to act as agent under the power of attorney as long as the person who set up the power of attorney is still alive. So to answer your question, if the person has passed away, then the power of attorney is no longer valid and you may not manage assets under that power of attorney. The next question is if I had a will, and I appreciate this question because it's part of our foundation documents, right? If I had a will and my will says I wanted everything to go to my children in equal shares, for example, this is an example, but I had a life insurance policy and it said I want everything to go to just my daughter. It does not matter that my will says children in equal shares. The beneficiary designation would in fact trump that, and it's called operation of law. It would go by operation of law. So to answer your question, a beneficiary designation under most circumstances would in fact supersede what the will says. Oh, I see some more.
Yep.
All right. In the hierarchy chart you showed, is this an automatic hierarchy, or my husband and child have to go to the court guardianship if you don't have a healthcare proxy? It is the goal of this new statute to have it be automatic. The only time you would have to go to the court regarding that is if there was a dispute under it. But a healthcare institution like a hospital could rely on this hierarchy without court involvement. Can you put the healthcare proxy language in a revocable living trust, and is it sufficient in place of the healthcare proxy? I would not recommend that. The healthcare proxy is the legal document regarding healthcare decisions. And what you don't want to run a risk of is a healthcare institution and or your agent under the proxy not being able to move forward with it because it is not under the correct legal instrument. So I would use a healthcare proxy and a living will to cover these kinds of healthcare issues. I'm 2 minutes over. All right, I think that's it. I think Ashley is frozen. So what I am going to do is I'm going to wrap up. I'd like to thank everyone for joining me today. We are with Russo Law Group. We thank you for coming. I think she's back. I stepped in your shoes for like 1 second, and I don't know if I lived up to how you do. So I'll let you take it over.
No, thank you. I didn't even realize I was unavailable. So I
Yeah.
appreciate it.
That's okay.
So what makes Russo Law Group different? Well, our clients tell us that it's our dedication, accessibility, scope of legal services, and years of experience that gives them the peace of mind and confidence when working with us. We will not learn at your expense. Long Island News called us the leading elder law firm on Long Island. We've helped over 17,000 families, and we help a diverse group of people. We are proud to discuss our services in your preferred language, including Spanish, Italian, Mandarin, and American Sign Language. Our firm has 11 attorneys, and we stand ready, willing, and able to step right in and help. We have 3 convenient office locations. We offer home visits and virtual appointments for you. We also have a peace of mind program that provides you with the security of knowing that your attorney is accessible whenever you have questions or potential problems or opportunities related to your estate plan, and it helps ensure that your comprehensive plan is well maintained. So if anyone has questions, please call our office. We are available to speak with you. Here are the services we provide and how we can help you and your family. We have a robust website, vjrussolaw.com. We offer terrific information, forms, checklists, resources, so take advantage of it. It's there for you. In closing, I just want to say that we appreciate all of you for joining us today. Please leave us your feedback in the post-webinar survey that will appear on your screen momentarily. And in case you missed any portion of today's program, we will email you a link to the recording. So Kim, thank you for your presentation. It was wonderful as always.
Thank you. And thank you, Ashley, for your coordination, and thank you all for
Sure,
joining
thank you.
us.
Thanks.
Have a great day.
All
Thank
right. Bye
you.
bye.
Bye.